Present, Mr. Chairman.
Representative Curtis,
Present.
Representative Garber,
Present.
Representative Heiberger,
Present.
Representative Hoheisel,
Present.
Representative Humphreys,
Present.
Representative Jennings,
Present.
Representative Keither, I see you. There we go. Representative Keither is present. Representative O'Habisam,
Present.
Representative Owens,
Present.
Representative Samsel,
Here.
Representative Warren,
Present, Mr. Chairman.
Representative Wheeler.
Present.
Very good. Okay, committee. The purpose of this meeting is to begin discussing with you some, well, as you've checked in your email, if you've had a chance to pull it up, we do have some documents from Natalie, which Natalie will go over here at some point in time. But we have, no, I've lost the documents myself, but she has an overview of what House Bill 2054 was, the bill that we passed Sunny Day that the governor vetoed last week. She has a proposed bill, which is 82, which you can read through, and then a comparison chart that compares House Bill 2054 and what is in this proposed bill. For not quite a week now, but close to a week, there's been discussions going back and forth with the governor's office on how we could take what was in 2054 and make it something that she'd be agreeable to. That's what is attempted to be put in this draft that you see before you. We are, I'd say 95, 98% there. This morning, we received some feedback on the liability pieces and have been working through those. There were some good suggestions that we received back this morning, worked on those. Earlier this afternoon, probably an hour or so ago, we received some additional comments back. Those we still need to work through and see where we're at. As we all know, nothing's ever final in the legislature until it passes both chamber and signed by the governor, but I feel like we're getting pretty close. And so the purpose of this meeting will be to kind of talk through where we're at and hopefully where we continue to go over the next day or however long we are back in the special session. The key pieces that Natalie is going to go over are the CARES Act funding. That was a piece, as you'll recall, in 2054. The LCC was going to have some oversight, and this will now say the State Finance Council. Looking at the Kansas Emergency Management Act, there's a number of issues in there that Natalie will review, and then the liability issue is the third big piece. So really, there's three chunks of items. The rest, if it's not mentioned as something that's changed, it has not changed. And again, Natalie, are you ready at this point to start walking us through some of these documents?
Thank you, Mr. Chairman. This is Natalie from the Revisor's office. Yes, I can go ahead and start that. So you have three documents from our office. The first is a summary of House Bill 2054. Looks like that. The second is an outline of the new proposal that looks like this. And the third document is a comparison chart that compares what was in House Bill 2054 to the new proposal that you're going to look at today. And that's the chart that I'm going to kind of work from to talk about some of these changes. So the first kind of section is the appropriations sections from 2054. The key difference here is that those funds will now stay in the coronavirus relief fund in the governor's department, and then the disbursements and expenditures from that fund will require State Finance Council approval as opposed to Legislative Budget Committee and LCC approval. The second chunk of sections there is the state of disaster emergency declarations and some of the KEMA changes. So new section 5 of this proposal will ratify and continue all the emergency declarations to September 15th of 2020. That section would then require the governor to go to the State Finance Council for any new state of disaster emergency that would be related to the COVID health crisis in 2020. And then new section 6 there provides limitations on the closure of business. So on or after September 15th of 2020, if there is a state of disaster emergency declared, the governor would not be able to order the closure of business for more than 15 days. And at least 24 hours before that order, the governor would be required to call a meeting of the State Finance Council to consult with the council about the need to close businesses. And then after that initial order of the 15 days, the governor would then not be able to close businesses without first going to the State Finance Council. And 6 of the 8 legislative members would have to vote in the affirmative for that to happen. And then closure of businesses would be able to happen on a 30-day rolling basis with approval from the State Finance Council each time. And that section then would expire on January 26th of 2021. So sections 32 through 35 in the draft. Oh, that's actually the last document for me. Sorry, you also have the draft, which Chairman indicated. So if you jump down to the bottom of that, sections 32 through 35 make changes to the Kansas Emergency Management Act. So section 32 is 48.924, which will provide that state of disaster emergency terminates on September 15th, 2020, except that when the legislature is not in session, the State Finance Council would be able to extend that on a 30-day rolling basis. And the extensions would not be allowed to happen after January 26th of 2021. Section 33 then amends 48.925, which is the section that puts the kind of limitations on the powers of the governor during a state of disaster emergency. And so it clarifies that the governor can issue those orders, but within 24 hours of the issuance of the order, the governor has to call a meeting of the State Finance Council to review that order. And then the changes in those sections also clarify that orders are null and void after the expiration of the state of disaster emergency. Subsection D there specifies that the governor cannot seize or authorize the seizure of ammunition or suspend or limit the sale of firearms. New subsection E provides that the governor doesn't have the power to restrict businesses from operating as except as otherwise authorized in the provisions that we talked about. And then new subsection F provides that the governor would not have the power to order or modify anything related to elections and the methods of our elections taking place. New subsection G authorizes counties to adopt orders relating to public health that are less stringent than a statewide order. So a board of county commissioners who would want to do that would have to make a finding and include those findings in the order that the board has consulted with local health officials regarding the order. Following that consultation, implementation of the full scope of the governor's executive order are not necessary to protect health, and that all other relevant findings support that board's decision. So that's the process they'd have to go to if they want something less restrictive than the governor's order. Section 34 amends 48.932, which is the state of local disaster emergencies. And it just provides that they may be reviewed, amended, or revoked by the Board of County Commissioners. Section 35 amends 48.939, which is the violations section. And so this should look pretty familiar to you. The bill, right now it's a Class A misdemeanor, so that's changed to a civil penalty not to exceed $2,500 per violation. Intentional violations will be enforced by the Attorney General or the county or district attorney. They can seek conjunctive relief. That's all the same as it was in 2054. So the next kind of bulk of sections in there deal with the county boards of health and the local health officers. So Section 25 is KSA 19101A, and that's the same as it was in 2054. Section 36 makes some changes, again, allowing the Board of County Commissioners to review, amend, and revoke those orders that are issued. And then Section 37, KSA 65202, again, is just language about letting the Board of County Commissioners review those orders and make changes to them. The next chunk is brand new. It wasn't included in 2054 at all, and it relates to school closures. So it's new Section 7 in your bill, and it requires the governor to obtain the State Board of Education's approval in order to close schools by executive order. And so that's a whole new piece there, and you can read that new section. The next chunk of changes are the liability protections, and those you'll see sections 8 through 15 of your bill. Section 8's the name, that kind of stays the same. The definitions are next. That essentially stays the same, except we did change the definition of a public health guidance. We changed that to public health directives, and it only includes mandatory directives, not just guidance issued by state agencies. The healthcare immunity is the same. The business liability immunity had just a couple kind of minor language changes. So I would suggest you read that section pretty carefully there. But the big change there is that nursing homes, adult care facilities were brought out into their own immunity section. They were given an affirmative defense as opposed to immunity to civil liability. So you'll see that in its own section there. And that section actually has a different definition for public health directives. It does not include local public health directives. So it would just be state statutes, orders, regulations, and federal statutes, orders, and mandatory guidance. Other than that, all the liability provisions remain the same for products liability. The retroactivity piece still remains in there. So the next topic is contact tracing. This is all new to this proposal as well. It was not included in House Bill 2054. It's at new Section 16 in your draft. So it creates the COVID-19 Contact Tracing Privacy Act. Subsection B is just a purpose statement there. Subsection C prohibits the state from contact tracing except when the Secretary of Health and Environment or a local health officer determines that contact tracing is necessary. And then subsection D provides that subject to appropriations, the Secretary of Health and Environment or a local health officer can employ, contract for, or engage contact tracers. And they would be operating under the authority of this section in compliance with rules and regulations that are adopted by the Secretary of Health and Environment. Subsection E provides that contact tracers will not disclose the identity of an infected person to a contact, and only data that's specifically authorized by the Secretary would be able to be disclosed. Subsection F provides that participation in contact tracing is voluntary, and no contact or infected person would be compelled from participating or prohibited from participating in a contact tracing program. And then contact tracers would be immune from civil and criminal liability. Subsection G provides that contact tracing would not be conducted through the use of any service or means that uses cell phone location data to track people. Subsection H provides that no third parties would be required to collect or maintain contact tracing data with respect to infected people. Subsection I provides that a person, it's the remedies section, it provides that people can bring a civil action to enjoin violations. A knowing violation of the act would be a Class C misdemeanor. And then contact data would be personal information and within the scope of the Kansas Consumer Protection Act. So an action could be brought under there too. Subsection J requires the secretary to promulgate rules and regulations. We have a definition section. And then this section would expire on May 1st of 2021. The next chunk in there is related to the employment security law. The unemployment stuff we talked about, that is all identical to the way it was in 2054. There are no changes. The health and healthcare portions. So we had telemedicine, temporary emergency licensure issues. We also made changes to the direction, you know, how those people have to be monitored and directed by a doctor. We made those changes, the hospital sections, all of that stuff is the same as it was in 2054. So no changes have been made to those sections in this proposal. Adult care homes, there is a minor change. So it used to be 30 days that the inspections have to happen, and this proposal would change that to 90 days. The alcoholic liquor curb sales, there are no differences between this bill and 2054. The courts provision allowing the chief to be able to do that audio-visual order while we're not under a state of disaster emergency, that's in there and it stays the same, no changes. The first responder part where first responders would be given information about whether someone was COVID positive when they went to respond to an address, that's in there, no changes made to that. The notary section where we ratified the notifications that happened, notarizations that happened remotely pursuant to the executive order, that stays the same as it was in 2054. And then there's a severability clause at the very end, and that is the same as in 2054. So, Mr. Chairman, with that, I think that kind of summarizes the new proposal and the differences between 2054, and I would be happy to take any specific questions.
Yeah, and before we ask questions of Natalie, just a kind of disclaimer that this was kind of divided up amongst revisors based upon their area of expertise. So Natalie may not have answers to everything for us, but will do her best. And really the purpose of however long this meeting lasts is just to get this information in front of you. I had not seen any of these things emailed prior to the meeting either. So it's all new to all of us. So this gives us some time to read it and look through it. Any questions for Natalie at this point? Claire?
Mr. Chairman, Natalie from the Revisor's office. I would jump in just to tell you that David Weiss is here with my office on this call as well. He's a budget revisor. So any appropriation specific questions he will be able to help us with.
Very good. Okay, so questions. Was it Representative Keither or Representative Curtis that raised their hands?
It was me.
And Curtis, and then Representative Carmichael.
Okay, just a quick question. I know you mentioned, Natalie, about that counties can enact less restrictive. Are they still allowed to also impose more restrictive local ordinances or local declarations?
So we don't make, sorry, Mr. Chairman, Natalie with the Revisor's office, we don't make any changes with respect to that.
Okay, thanks.
So next is Representative Carmichael, and just so you know the list, then we have Hoheisel and Owens. So Representative Carmichael and Humphrey.
Thank you, Mr. Chairman. John Carmichael from the 92nd District. You indicated that with respect to contact tracing, that contact tracers would be given immunity. But then you went on to say that there is injunctive relief and criminal penalties for violating whatever they're supposed to be doing. How do we give people immunity and at the same time prosecute them?
Mr. Chairman, Natalie from the Revisor's office. I believe the immunity is not necessarily, the immunity for the contact tracers, the people who work for KDHE or are contracted with KDHE, is different from violation of this section. So say someone tried to force someone to participate in contact tracing, that's not allowed by the act. So that would be a violation. So the violators, I don't think it's envisioned that the people violating the act would be the contact tracers themselves.
So why do contact tracers need any immunity? What are they being held immune from?
Mr. Chairman, let me get that specifically in front of me here. Whether or not to give them immunity, of course, would be a policy decision for you all.
Right, but I'm just asking as drafted, what are they immune from? Is this another civil liability immunity statute? I thought it also referred to criminal prosecution, and I haven't read any of it, so.
Well, and Mr. Chairman, just to clarify that, I think what this would be more similar, not this, I wouldn't liken this to the business immunity provisions. I would liken this to the provision, for example, that we have like in good time and program credit, where we don't hold the Department of Corrections liable for mistakes that they make while they're calculating good time credit. So it's more of like an employee immunity provision.
Well, with respect, that doesn't make a lot of sense, but I'll read it for myself. Thank you, Natalie.
Representative Hoheisel. You're muted, Nick.
Gotcha.
There we go.
All right. Thank you, Mr. Chair. And thank you, Natalie, for your hard work on this. I had one quick question about the healthcare and business liability. Is the IDD provider still in that section?
I'm sorry, you're gonna have to explain.
So, yeah, in the healthcare, in the original bill, the original draft, the IDD providers for IDD services were not in that original bill. I believe there's an amendment in the Senate to add them in. I believe they did get added in. The governor vetoed the bill. Are they in this one, this proposal?
Mr. Chairman, the provisions related to healthcare immunity in this bill are identical to what was in House Bill 2054.
The House Bill 2054 that we passed, not the original version.
Correct.
Okay. Thank you, Mr. Chair.
Natalie, just to clarify that though, I thought we excluded, and now I'm trying to find it myself.
Oh, we did. Are you talking about the definition of the healthcare provider?
Yeah, so we pull out, let me find it. Yeah, go ahead and explain what you were about to explain while
So in the definition, because we created a separate section for adult care facilities, we pulled them out of the definition of a healthcare provider. So you'll see that that definition, it used to say, the definition of a healthcare provider, including hospice providers and any facility licensed pursuant to Chapter 39. But now that definition still includes hospice providers, but excludes any facility licensed pursuant to Chapter 39. And then we have our own nursing home section that just covers 3 of those types of providers.
Okay.
And so because of that, Representative Hoheisel, I believe the IDD is no longer in here, but we'll have to confirm because I think they're in that. We'll have to double check that. I think the intent was them to not be in here any longer, but we better double check that.
Okay. All right. Thank you, Mr. Chair.
Representative Owens, is your hand still up or did you put it down?
Representative Owens, 74th. Actually, good Representative Carmichael asked my questions and got that clarification for me. So thank you.
Very good. Representative Humphreys.
Thank you, Mr. Chairman. Susan Humphreys from District 99. Natalie, just a quick question on page 3 of the side-by-side. Section 33 says the governor shall call a meeting of the State Finance Council for the purposes of reviewing such order. Does that mean they have any sort of veto power over it? Or, I mean, it just says review. So wondering what that means. Thank you.
Thank you, Mr. Chairman. I'm just getting to the exact language. And if you're looking at the draft, if you go to page 71, so it's in subsection B there. And it just says that the governor shall call a meeting of the State Finance Council for the purposes of reviewing such order. So that's all that's provided for in that section.
Okay, thank you.
To clarify, but if it has to do with business closure, they would have a vote. Is that correct?
Mr. Chairman, so that's almost like a separate, the governor would come and request that. So yeah, there would be a vote if it has to do with an extension of that 15 days for closing business.
Representative Samsel.
Thank you, Mr. Chairman. Good afternoon, committee. It's nice to be meeting with everybody at 4 p.m. instead of 4 a.m. Very big picture question for you, Natalie. Thank you for all of your work on this. My question is, has any thought been given, and there's lots of good stuff in here, so I don't want to lose it, but the Constitution has a one subject rule. I'm not giving it much thought. I just pulled it up because I know it's there. It's Article 2, Section 16. I suspect that hopefully the argument would be that this is all COVID-19 related, so we could do all of this. But has that been given any thought yet? And then if it is challenged on that ground, and if we don't separate these things out, is there some language in, or what would happen if, let's say, I don't know, maybe the audio visual, just as an example, if that was determined not to be the same subject as all the rest of it, do we lose the whole thing, or do we lose just that one small topic?
Mr. Chairman, Natalie from the Revisor's office again. As we draft, some single subject is something that we're always considering and trying to make sure that we are complying with that. You have the rule there, so you know what it says, and I guess you can make arguments for or against whether this is single subject. It is all related to the COVID-19 pandemic, and you'll see in our title, sorry, a lot of scrolling here. The kind of first part of our title, which is what we would view as the single subject of the bill, would be the governmental response to the 2020 COVID-19 pandemic in Kansas. So, whether that's a viable single subject or not is something for the courts to determine. We do include a severability provision in there, but as we all know, severability is something that's up to the court's discretion. So there is case law on single subject. I have read some cases where, the whole bill falls if it's determined to not be single subject.
Thank you, Natalie. Mr. Chairman, I guess my just thought with that is if we're going to put a lot of time and effort into it, and there's already been a ton poured into it, I think Natalie said it best, that there's going to be arguments if we keep all of this in one bill here, that it's at least not one subject. Certainly, we've got plenty of good lawyers that can argue if it is. But if we're going to do all, I just wonder if it makes sense to break these down by topics. That may be a bit more work, but it sure seems like it's much more, it's less subject to attack by constitutional grounds. And of course, our taxpayer dollars are more important now than ever with COVID-19. So anything we can do to keep us out of the courts, I think would be a good thing. And again, I don't express any opinion on any of the content of this bill. I could be persuaded to support any or all of it or none of it, just depending on where we go. Obviously, haven't studied it yet, but that's just my big concern with a procedural thing on this. So thank you, Natalie. Thank you, Mr. Chairman and committee.
Representative Warren.
Thank you, Mr. Chairman. Kelly Warren, House District 28. I have a question concerning new section 11. It's on page 11 of the bill, or the proposed bill here. I was looking to see if there was a definition section, because section 11 talks about a person or an agent of such person conducting business in this state shall be immune from liability. Businesses are considered persons. Do we have that definition somewhere, or is this actually individual persons? Could you clarify?
Mr. Chairman, thank you. Natalie from the Revisor's office. If you go up to page 9, that definition section included there in new section 9 is incorporated into the COVID-19 Response and Reopening for Business Liability Protection Act. So that's the definition of person that would be used there.
Thank you. I wasn't checking section 9 in advance of my question. And if I could have one more question, Mr. Chair.
Mhm.
Thank you. Kelly Warren again, District 28. When you were reviewing what the bill proposes to do, we were talking about an affirmative defense, and section 11 new as written talks about immunity from liability in a civil action. Could you explain the difference?
Thank you, Mr. Chairman. Natalie from the Revisor's office again. Yes, so if you look at sections 11 and 12, those are the business and products liability immunity sections. Those provide, we use the words immune from civil liability. In the adult care facility section, we say that those adult care facilities shall have an affirmative defense in a civil action for damages. And fortunately, we have a lot of very experienced civil litigators here, and I'm sure you will get into discussions about this. But in theory, if you have immunity from liability, your case would maybe stop at an earlier point, whereas an affirmative defense, you're going to have to actually use that at, say, trial to say that, you know, you have a defense to liability here. So, but again, I'm sure Representative Ralph, for example, can expand on that.
That was my understanding of the difference as well. Between immunity and affirmative defense, and thank you very much.
Representative Jennings.
Thank you, Mr. Chairman. A couple questions for Natalie. First of all, section 1 of this bill appears to be couched in terms as an appropriation. Is this an appropriation? Section 1.
Mr. Chairman, Natalie in the Revisor's office. Yes, so we would say that sections 1 through 4 are considered appropriation sections, and my colleague David can answer any specific questions about those.
Well, I guess the specific question would be, is there not a prohibition of having an appropriation bill that also contains policy otherwise that goes beyond the appropriation?
Mr. Chairman, this is David Weiss with the Revisor's office.
Yeah, go ahead, David.
There isn't any particular prohibition having appropriation sections and substantive sections, provided that the underlying subject matter is, in this case, a response to the COVID-19 pandemic. Okay, so I think that is the sort of the overarching subject matter of this bill, and the appropriation pieces here, sections 1 through 4, deal with that subject. As with the others, you might remember a few years ago there was a court case in terms of where there was an education policy and some education appropriations within a bill. The Kansas Supreme Court said that, considering all that was in the subject matter of education, they allow that to stay and have a problem with that. So I don't believe there'd be any prohibition under this bill.
Okay, great. I appreciate that. Mr. Chairman, one more question.
Yes.
And I think this would be for Ms. Scott. There's a section of this thing with respect to closure of schools. And as I understand it, it contemplates the governor would be faced with a circumstance potentially that closure of schools seemed to be something that she would like to do, that she would then contact the State Department of Education, ask them to convene a meeting of the State Board of Education to consider whether or not they would approve of her entering an order under her executive powers to close school. Is my understanding correct?
Mr. Chairman, Natalie in the revisor's office again. If you look at the draft on page 7, that specific language is in new sec 7. So the last sentence there that says, upon the receipt of a proposed executive order, which would be the executive order proposing that they close schools, the state board shall meet as soon as reasonably possible to review such proposed order. And if a majority of the members of the state board determines such order is in the best interest of the students in this state, to adopt a resolution affirming such proposed executive order.
Okay, I guess that's my questions. Am I allowed to make a comment, Mr. Chairman?
Sure.
I would just say that I think it was described to me by someone not very long ago that the benefit of the chief executive having these emergency powers is that the governor can be nimble in their response to an emerging threat. And I guess I have a little bit of concern that somehow on the one hand, we want to convey the ability to be nimble, but by the way, not too nimble. Now you're going to have to go to the State Board of Education to get their approval to enter an order to not have school. And I guess I would hope that perhaps it could be couched in other terms, that the order could be entered on an immediate basis and become effective immediately and perhaps ultimately ratified or not by the State Board of Education. But in some circumstances, time may very well be of the essence. And whether it's a day or two, in this kind of circumstance, it could make a difference. And these are kids. So I guess I would prefer erring on the side of protecting children at first, and then let the state board think about whether or not that would apply. The other concern I would have is, I guess maybe it's a last question for Natalie, is what would the interplay be between the authority of boards of county commissioners to articulate lesser restraint within their community on executive orders as it pertains to public schools?
Mr. Chairman, that is a good question, one that I think would be best answered by our education revisors. So I can take that back to them and ask how that would affect this.
Well, last comment then, Mr. Chairman. We absolutely should not have a multi-tiered approach to determining whether or not schools are going to be closed only to have a board of county commissioners locally say, oh no, it's okay, go ahead and open the schools. So if nothing else, we need to find a way to be sure that that can't happen.
Very good. Let me check for blue hands. I don't see any. Representative Carmichael has not a blue hand, but he's raised his hand.
Thank you, Mr. Chairman. John Carmichael from the 92nd District. There has been talk earlier in the week about perhaps establishing a fund to compensate essential workers who contract COVID and under circumstances where they're not covered by workers' compensation. Has anything like that been included in this 82-page draft bill?
I don't believe that. Natalie's about to answer. I don't believe that's in here, but I heard those same things. In fact, just this morning, Representative Carmichael about trying to allot some money for that. So it's not in here, but I know I've heard that same conversation.
Yeah, and then with your leave, Mr. Chairman, we've had a lot of concern over the past several years about bills just showing up in committee that nobody takes any responsibility for. They don't put their name on it. Somehow it just becomes law. I don't think that the revisors probably sat down and made these policy decisions. So this draft that we are looking at today, who okayed it? Whose idea is it? Who approved what's in it? Can you give us any idea about where this monstrosity came from?
Well, just to kind of go back to the beginning, I mean, it's been discussions with the governor's office going back to 2054. What pieces was she okay with, not okay with, what needed to be tweaked? So really it came from that conversation, and I don't know who else all been involved, even myself. I know there were pieces that have all kind of been put together. So I don't have an answer for you yet, but I can certainly get into that.
And I'm sorry to press you a little bit, Mr. Chairman, but typically when documents are presented to a committee, somebody takes responsibility for them and says, this is my testimony, or this is my proposed balloon. But here we have something that, as far as I can tell, the revisors decided what was going to be in it. And I think people are entitled to know whose ideas these are, because I've been having people who've been involved in these discussions all week emailing me as we've sat here saying, this isn't what we've agreed to. So I'm just trying to figure out, in hopefully a constructive way, is this the governor's proposal? Is this Chairman Patton's proposal? Is this Blaine Finch's proposal? Who's it? What is this?
Okay, we'll work on getting answers to all that, because again, like I said, this is the first time I've seen it all put together as well.
Okay, so it's not the chairman's proposal. We know it's not yours, and it's certainly not mine. So that's two of the culprits that we can take off the list.
Representative Owens.
Thank you, Mr. Chairman. Stephen Owens, 74th House District. So are we past discussing this with the revisor, and have we moved into additional conversation, or are we still focused on revisor only questions?
Does anyone else have any questions for Natalie at this point? If not, sure, let's have a little discussion. We'll see where we go. And I know this question will come up probably from Representative Keither about where do we go next? I don't know that answer yet. Even myself, I know we're having a hearing today, and this is not even really a hearing. It's just an informational hearing over this. So I don't know what's next. I'm waiting just as everyone else is. So Representative Owens, back to you.
Well, thank you, Representative Owens from the 74th yet again. I want to follow along with Representative Carmichael's questioning of where does this come from, why now, and to what extent the governor was involved in it. I mean, as we said here, having listened to this updated proposal, I think it's really important to recognize that this would be, assuming this becomes a bill, the third attempt to provide the governor with a path to extend this emergency declaration. I mean, first, we tried to do it by giving it to the LCC, giving that authority to the LCC. And ultimately, when challenged, she sued us and threw that out. Second, she was provided with a piece of legislation that allowed, the same thing that we just reviewed, allowed for an extension, and would have even further done what the Attorney General requested, and that was codifying some of the previous emergency declarations. So, here we are onto a third attempt to accomplish what we set out to accomplish without having to spend additional taxpayer dollars, by the way. As I understand, about $40,000 to $50,000 per day of taxpayer dollars when we're in a funding crisis as it is. So, is anybody from the governor's staff on this call? And can anybody speak to the governor's involvement in these conversations? Or I guess my real question, Mr. Chairman, is should I just prepare additional time in June or July to come back and do this again if she vetoes it all over again? I mean,
Right. So I'll tell you that the original goal during this meeting was to have someone from the governor's office here. But as I said, we're only 95, 96, 97% there. And until we had final language, and despite Natalie working around the clock, literally working around the clock, this didn't pop in our emails until just a little bit ago. So the final language did not have a chance to be reviewed and approved. And so that's why there isn't anyone here from the governor's office, but
not to interrupt, and Natalie is an absolute rock star, as are all the revisors and staff members. They work their tails off for us. Why the third attempt did it take the governor's office to sit down with us? I'm sitting here a bit perplexed at us going through this process again and again and again in hopes that the governor, gets exactly what she wants, or she's just going to veto it and issue additional executive orders or emergency declarations every 15 days. I'm just trying to figure out where's the end of this madness as it relates to these emergency declarations and what we're trying to accomplish here.
I understand your point. Not sure I have an answer.
I recognize that. A bit rhetorical, I think it's worth saying that we're wasting, taxpayer dollars yet again.
Representative O'Hobison. Did you mean to raise your?
Yeah. Can you guys hear me?
Yes.
Okay. Representative Officer, District 89, Mr. Chairman. My question is it possible that either tomorrow or we have like a hearing per se, it's like everything comes this way when we have the papers, so that maybe can have another hearing on this particular matter, or you can attorney general or whoever so that the committee is actually well informed per se if we move forward on this. Is that a possibility? Not a possibility? It's just thank you.
So you were cutting out a little bit, but I think the point you were trying to make, or question you were trying to ask, is: are we going to have a full bill hearing on this? I think that's what I was getting out of what you're saying. And again, I'm not sure what happens after this meeting. I just know we have this meeting, and I think I read that we show up at 8 o'clock in the morning. So beyond that, I'm not sure what's next. I'm ready, willing to do whatever we need to do to move this process forward. And I guess we'll find that out in the morning.
Thank you, Mr. Chairman.
In my opinion, nothing's off the table, I guess. Let's put it that way. So further questions or comments at this point? While you're still thinking of raising your hands, Representative Keither, I do want to, for one, thank you all who originally moved things around to meet at 9 o'clock this morning, and then it moved till 3:30 this afternoon. And I know you had to juggle stuff, and some of you are literally driving right now, and others came to Topeka early or late. And again, I apologize for that, but things have been changing, and Natalie is still talking to me, so that's a good sign. At least I think she is. Did she disappear? Maybe Natalie left. Representative Keither?
Yes, thank you, Mr. Chairman. Annie Keither from Topeka 55. I would have to echo some feelings that have been spoken about here. I really would like to strongly state that I am not interested in going through what we went through with Sine Die, in that we're having an informational hearing and no input on the piece of legislation that we're talking about. We got it back as the Senate sent it over to us. And I'm not interested in doing that. I think we need to have a House position. I think we need to have a meeting about it. That's what our job is, and not just to send it over to the other chamber. So I would strongly emphasize that I would like to have a meeting. We're going to be there. We ought to be doing our job. And so I strongly suggest we need to have a judiciary meeting to pass this bill and have a House position.
Okay. Representative Jennings?
Well, thank you, Mr. Chairman, Representative Russ Jennings, 122nd District. It strikes me that there are at least 3, if not 4, different subject matter topics that are included in this one bill. And I totally understand the idea that there may be some economy and there may be some overarching circumstance, the COVID-19 pandemic, that all of this falls within. But it strikes me that these really ought to be broken into separate pieces. If it takes 4 bills, it takes 4 bills. Address the appropriation piece. We do not go into the budget debate and have discussions about adding substantive law as a part of the overall budget for the state because it's prohibited. We can do provisos that do a little tinkering. And while there may be a technical way that this can actually occur, it strikes me that in the last months in particular, we have wandered farther and farther and farther away from adhering to the rules and potentially the Constitution in some of the things that we've been doing. And I've heard it from plenty of friends in this legislature who have said, the Constitution is not suspended because of this emergency. And we should govern ourselves in a way that demonstrates not only do we say it, we believe it. And that we will be transparent and we will have public hearings with the opportunity for the public to appear. And even if that's by some remote video thing that they feed into us on all of this, there's no one's here today. We're having a nice conversation. The next step, my guess is the master plan would be, oh, we'll just go on general orders with debate and amendment on the floor without any committee recommendation whatsoever. And that will take a 2/3 vote, and my vote will not be one of them. So we can start doing it right. We have no constraint of time, and we should pass a product that in the end serves the interests of Kansans and is likely to be signed and become law so people are not back here in July or later this month in June. We've done it quickly and messily twice and it hasn't worked. Let's get it right the third time.
Representative Samsel.
Thank you, Mr. Chairman. I also don't want to talk long, but I do want to echo what I've heard from many people on this committee, but just add a couple things to that. I also want to know where this bill is coming from and who's supporting it, because I'm not trying to be difficult, but why is there a reason that we cannot break this down into smaller pieces and get it right? And one of the reasons that I mean that the most, and for 2 months now, I've been trying to get oversight over the governor. My rural part of Kansas needs it. I mean, I've got one county to date that has still had only one county. And where I do not want this to go is to have oversight provisions in this very large bill and then have those get challenged in court. And it's no secret that it's ultimately going to go to a pretty liberal Supreme Court. And I don't want them to be able to strike that down for some other constitutional reason when we're aware of it right now. So I would like to be able for this committee, what I said on the House floor at 4 a.m. or whenever it was, I absolutely mean it. I respect the heck out of the people on this committee. We may not always get along, but there's some very intelligent people. The lawyers are okay. The non-lawyers are even better. But when we come out with a House position, it's a pretty dang good one in my opinion. So I would like to be able to do that one. I would like to be one that we can all stand behind, say we had input in and be proud of. And I would like to be one, if somebody wants to sue us on it later, we can go to the Supreme Court and have the best chance of that being upheld and not a waste of all of our time and effort over these next days or weeks or whatever it may take. So those would be my hopes that we can do this moving forward. And to echo what the previous speaker just said, in as transparent a manner as possible, let's make sure we do it the right way. And I think just so that we are clear here, though, this is not a bill that we're able to work at this time and perhaps may not be able to work depending on where things go. Is that correct, Mr. Chairman? I mean, we're not entertaining any motions at this time to work the bill or conceptual motions or anything like that.
It's not, I mean, the new session has not even begun. So it's not even a bill until session gavels in tomorrow and we decide what happens then. So no.
Okay, thank you, Mr. Chair. I just wanted to be sure that if we debate this in the very near future, that there was a suggestion by someone that we had the opportunity to do something, whether it was work the bill or change the bill or introduce something else to this, and then that I didn't do it just because of my own lack of understanding or something of that nature. So I thank you, committee, and thank you, Mr. Chairman.
Representative Warren.
Thank you, Mr. Chair. Representative Kelly Warren, District 28. Appreciate the discussion and conversation. I I don't have a position. I don't know what the answer is about whether putting all these subjects into one bill would withstand constitutional scrutiny. We certainly want to operate appropriately under the Constitution, of course. My concern is that, and we've got businesses who have been asked to shut down, and then during the stay-at-home orders were shut down as well. And they have reopened. They have been operating sometimes a week or so, sometimes less. And how can we get this legislative body, not just this committee, but the legislative body in a position to help our healthcare providers, our hospitals, our small businesses, nursing homes, PPE manufacturers. I mean, the more days that go by where we don't have anything in place that we can get this Kansas economy recovering, it puts the state of Kansas in further dire straits. So I know we don't really know where we're going with this, but how do we get to a point where we will know? I mean, we are the House Judiciary Committee, and I would like to make progress on these issues for our state and our constituents. So it's kind of a hypothetical question, kind of not, but I'd like to see the process moving forward, and whether that's getting someone from the executive branch here on the conference or at a committee hearing, let's do that.
I absolutely agree. Representative Carmichael, did you start to wave a little bit ago?
Yes. Yes, I did. Thank you for your patience, Mr. Chairman. John Carmichael, State Representative for the 92nd District. First, I couldn't agree more with my colleague, the Chairman of Corrections and Judiciary. We're making, I wish we hadn't had this meeting, because this didn't really accomplish anything. We can't read an 82-page bill. And we're going to show up tomorrow and people are going to say, well, House Judiciary had a hearing on this bill, and so we're just going to run it across the floor, and we want you all to vote for it. As we have sat here, I've received an email from an agency head of one of the most important agencies involved in this COVID response, who tells me that he has serious objections to what's been thrown on the table here, that he even prepared testimony to submit to the committee, but it was refused. What are we doing here? This is just about as close to violating the intent of the Open Meetings Act as possible. We have a bill here that I have no idea who's cooked up this bill. So far, the finger is only being pointed at the revisor's office. And we're going to come up here tomorrow, and exactly like Chairman Jennings says, somebody's going to try to shove this through. And we're going to make terrible, terrible mistakes. We ought to sit down, take our time, do what's necessary, do our job, hold hearings. All of us catch COVID, take it home with us, because some people in the legislature, after they voted unanimously in favor of extending this declaration, decided they're going to change their minds and they want to fight about it. But we can't do business this way. People who have good ideas and need to be a part of this process have been affirmatively excluded from this process, myself included, and I don't appreciate it. That's not a criticism of you, Mr. Chairman. Thank you.
Thank you. And just to clarify, I have not intended to exclude anyone, and I thought it would be helpful to get this to you as soon as possible. Again, not knowing where it goes, but I think getting it in your hands today is better than getting it in your hands tomorrow. I do encourage you to read whatever you'd like to read. Again, nothing else, that gives us a head start, and we've had a little bit more time to digest at least the pieces of whatever a solution may look like. Anyone else? Seeing no blue hands, but I think one ear from Randy Garber. Let's see. Okay, committee. Well, I appreciate your you're, again, making time for this today. I do encourage you to start diving through the materials, reach out to those that may be interested. I think we know what the topics are going to be. I don't think we know for sure what it's going to look like, but certainly these are the issues that have been raised multiple times now, as Representative Owen said. And so I hope you've all been spending time soliciting input and figuring out what needs to be in whatever type of package or individual bills we come up with. So with that said, again, thank you all, and I'll see you bright and early in the morning. Have a good evening.